Welcome to another episode of The Dissection. Today, Advocate Shamila Bathohi, the head of the National Prosecuting Authority, refused to give a key name to the ad hoc committee in public. And I think it matters to look at that moment because it's a critical moment in her testimony, and there are some legal questions that arise as a result of that particular answer and that strategy that she adopted. You know, there's a consistently repeated maxim in law. It's so common it's repeated around the world. The maxim is as follows: justice must not only be done, but must also be seen to be done. Justice must not only be done, but must also be seen to be done. Now, this dictum was laid down by Lord Hewart, then the Lord Chief Justice of England, in the case of Rex versus Sussex Justices. Now, the facts in this case are actually very interesting. I'm going to go over the facts so that you have an understanding of what was actually happening in this case. Now, there was one Mr. McCarthy who was driving a motorcycle. His motorcycle collided with another motorcycle that had a sidebar, which was driven by Mr. Whitworth. And this motorcycle, which was being driven by Mr. Whitworth, had his wife in the sidecar. You know, those old school motorcycles. So both husband and wife sustained injuries in the collision, and the police then instituted criminal action against Mr. McCarthy. What then happened was Mr. Whitworth also engaged a law firm of solicitors, and this law firm was Langham, Son, and Douglas, to proceed against Mr. McCarthy for damages. Now, the criminal proceedings were taken up for hearing before a bench of judges in Sussex. The clerk to the justices, Mr. Langham, was also a partner of the law firm that was engaged to sue Mr. McCarthy for the damages. So Mr. Langham was part of this firm which was suing Mr. McCarthy, the guy who hit, Mr. Whitworth and his wife. Now, as Mr. Langham was on holiday, his younger brother acted as a deputy clerk on the day of the hearing. And incidentally, that younger brother was also a partner in the same law firm. After the hearing was over, the justices retired to their chamber to consider the decision, and the deputy clerk also retired with them. After some time, the justices returned to court and they declared Mr. McCarthy guilty. They convicted him and imposed a fine of £10 with costs. McCarthy appealed this decision, and he won the case because of the presence of that deputy clerk in chambers when the justices were deciding. So Lord Hewart, I hope I'm pronouncing his name properly, went on to observe that what was important was not what was actually done, but what might appear to have been done, and held in his judgment the following: nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice. I'm going to repeat. Nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice. One more time. Nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice. So his view was actually concurred with by the other two judges, Justice Lush and Justice Sankey. Justice Lush observed that even though the trial judges did not intend to do anything irregular or wrong, they placed themselves in an impossible situation by allowing the clerk to retire with them to the consultation room. Today, something happened in that ad hoc committee, which I think actually undermined the dictum of the judge in that seminal case, one which is a UK case but whose principles have been applied in South African justice system and also around the world. So when you read judgments on these types of principles, it often will go back to this seminal case, the Sussex case. The National Director of Public Prosecutions basically provided an obstruction for the public. She obstructed a clear view for the public to ascertain for themselves if there are any issues with the NPA, how it's working. She may also have created suspicion that there is interference. She may have blocked justice from being seen to be done today. And she may have created that suspicion that Lord Hewitt was referring to in that case of Rest versus Sussex. Let's look at this exchange and you'll see why I'm saying this.
During a media interview on the 5th of June, I made comments relating to infiltration of the NPA. And the next day, I then also had another media interview where I sought to clarify what I meant by that. I want to explain that the reason that I made these comments at the time was that I had received confidential intelligence that there was a very concerted attempt to compromise members of the prosecuting authority. Also, concerted attempts to undermine and attack the national director, and by individuals that are seeking to undermine the rule of law in this country. I'm not able to say who gave me this intelligence, but it was not passage talk. It was a formal meeting that I had with a particular agency, a member from a particular agency, and who gave me this information because the person thought it was important that as the head of the NPA, I should be aware of this attempts to undermine the work of the NPA. These were very serious. I was informed that the matter will be reported to the president, but I immediately informed the Minister of Justice about this and had a meeting with her when I briefed her on what I had been told. I also, at some time later after that, when the president was available, met with him and briefed him about my concerns about this. And my understanding is that there was not and this is my understanding, I'm not sure how these agencies work, but that there wasn't a particular tasking to look into the NPA. But I asked the president, I said to him, it's important that we understand what is going on and that there should be a tasking by our intelligence services to properly look into this matter. We work in a work environment where we don't know who to trust. That is the reality. Even sometimes within the prosecuting authority, definitely within the SAPs and other partners, we work under conditions where you do not know who to trust.
At paragraph 73, you reference receiving information also from the National Commissioner and from the National Commissioner and Lieutenant General Khumalo about potentially corrupt.
That's correct. So, Honorable Chair, I received information from the National Commissioner and General Khumalo about a particular member of the prosecuting authority who was involved in organized criminality. I am not going to mention the name of that prosecutor in this House. The matter is under investigation. I immediately, upon receiving that information, I made a formal referral of the matter to the IDAC to investigate the matter.
What's the status of this particular prosecutor given these serious allegations coming from high-ranking
I don't... The prosecutor is under suspension.
Okay.
Advocate Bathohi is saying he can't reveal the name here. But if it's the same person who was mentioned in the media, why not revealing it here? Because in the media, if as members here of the committee and the South African, some people knows exactly what we are talking about. Who's that person we are talking about? Why are we hiding it here?
Chair, if I may ask the name of which person, the person in the media or the person in respect of whom the information was received?
No, the person you mentioned that is sitting at home, the prosecutor, which you said is sitting at home as we speak here.
I do.
But if it's mentioned in the media and it's the same person and he says it's a secret, For me, that's a double standard. I mean, we deserve to know as well, formally so, not from the media. But if it's a different person, it's okay.
Yeah. She says for the purpose of professionalism. Honorable Malam.
No, thanks, Chair. I thought she was suggesting we must just go home if she's going to proceed like that. Because we deal with names here. What are we dealing with? What are we dealing with here? We want to know who captured the criminal justice system. And if we can't be told names and we accept that, let's go home. Especially names that are out there. There is a prosecutor, I'm just forgetting the name of is it Johannesburg or something, Pretoria, who's suspended by the president? Joburg, Chauke. What's difficult saying something like that? What's difficult saying something like that? If we're referring to Chauke, or if there is more, we need to know. There is nothing unprofessional about that, because if we're going to proceed like that, we're becoming toothless. We cannot allow a situation where there is an allegation of a prosecutor who is being captured or infiltrated, and we are told we can't be given a name. If it was wrongly mentioned, there are recourse in South Africa where that name will be cleared. There are so many names of people being said here, people who are also in jail, people who are already on criminal trials. We get deep into those issues because we're seeking to unearth the truth. If it is true, indeed, there are people who are captured in the prosecuting authority. We want to know that. What if Chauke is wrongly accused? What if he's correctly accused? We need to come to a determination that, look, there is nothing in the NPA that suggests there is any infiltration by the drug cartel or anything of that sort. Or there is. And if we say there is, these are the issues. And these are the individuals responsible for those kind of activities in the NPA. So I don't think Honorable Skhosana is being irresponsible in that regard. Thanks.
Advocate.
Thank you, Chair. I really want to emphasize, honorable members, that I do not seek to be disrespectful to this committee. I haven't even said, the members have mentioned names. I haven't even said whether it is or isn't that name that has been mentioned. And I don't want to make it difficult for this House to be able to do its work. But given that I was given, I think at the level of intelligence, because I haven't even said it's evidence, I went back to the National Commissioner as well as General Khumalo and I said, can you please give me evidence of this? Because I need more evidence. And so I really urge that it will be hugely irresponsible of me to mention a name in this House on the basis of intelligence that I've received that may or may not be true. So I really urge honorable members to understand that I do want to help this House, but I do not want to put people's names at risk. For various reasons, you never know how people are put at risk. I mean, and we don't know whether it was a direct consequence of what happened in this House, but you know that our chief investigator of the IDAC was attacked a day or two after his name was mentioned in this House. But one might say, look, he is the chief investigator. It's not difficult, that you shouldn't really draw that conclusion. I will understand that as well. But it does put people at risk. And I do not want to be irresponsible and do that when all I've received is intelligence about the possibility that about the fact that somebody is involved with organized criminal networks.
I think this was very regrettable. And I think that even though now Parliament has insisted that this be heard in a closed session, I think it is still deleterious and still damaging to the public's understanding of this case and creates this unequal platform where some names are more important than others and where the public may never know the identity of this person and some issues may arise from that identity being obscured. So let me give you my thoughts about this answer in sequence. Number one, I think that the refusal to provide the name of the implicated prosecutor is something that obscures the public view of the justice system and undermines the trust of the public in the office of the National Director. This is an office that has incredible powers and as such must make sure that those powers are exercised with maximum transparency and with maximum accountability. I think the decision to refuse to disclose that name undercuts maximum transparency and maximum accountability. I also think that it's something that leads to just questions from the public around consistent hesitancy by the director to disclose some information. She said that the NPA was infiltrated earlier in the year, then refused to disclose information on the nature of that infiltration, then seemed to be backtracking on the extent of that infiltration, although initially she was suggesting the reason why they haven't had the successes that people would expect them to have is due to that infiltration. This kind of conversation where you make these bold allegations and then pull back without giving the information creates almost as if it's a narrative designed to protect yourself from further scrutiny and creates a scapegoat which you don't wish to identify explicitly. There's someone who's infiltrated the NPA. I can't tell you who it is. And where there's a specific allegation made by other people, then you say, no, we're not going to discuss that in detail or in front of the public. Just trust that we're dealing with that. And then argue that the reason why you're doing that is to protect, the rights of that particular person. I was not fully sold on that. Number two, I think that the refusal to mention this name also denies this particular person the space to also come and spill the beans to the committee and to the world and potentially also to the Madlanga Commission. Think about this. We initially thought that Bheki was a key person in the allegations around this cartel and the Hoshkari behavior. And we thought so because he had met with Matlala, he had been at the penthouse, he had met with him at Zimbali, the house of Hangwani Maumela. When he came to the ad hoc committee, he admitted freely to taking the freebies. He provided key testimony around people's relationships with Vusi Matlala. He actually went against the cartel. He backed Khumalo, and he actually rebutted the version of the minister, Senzo Mkhunu. And actually, as somebody who has had extensive experience in policing, was able to explain why the interministerial committee continued to operate, why the task team was valued, and how the decision to disband the task team by the minister in the way that he did it was unlawful, irrational, and seemed to be driven by ulterior motives. All of this came from the testimony of Bheki. Now, this particular witness, if he was known to South Africa and the public, could come to the commission and also share his experiences or her experiences of working with Shamila Bathohi, tell us what has been happening in respect to infiltration. They may even share more information to get a plea deal later. Or if they feel like they're being thrown under the bus, they may actually, or being used as a scapegoat, may actually tell us more information than what we currently have. Because Bheki came and he was setting everything on fire. He didn't come there to play games because his name had been mentioned and aspersions had been cast about him. Now, they may not do any of these things in this particular instance because the public will not know. That public attention, which could have been impetus or a driver for maximum transparency so that that person protects their legacy, will not happen now because all of this may now be done in a veil of secrecy and we may never know as the public, which is something damaging. Now, my third point is there was a lot of reference to secret things in the answers of the National Director, where we just have to take her word for it and where there's no further exploration available. So if you think about the state intelligence function, she says she got some information intelligence from one of the agencies and she says she doesn't understand how the agencies work, which to me is worrying because you're the National Director of Public Prosecutions. You should have a better understanding than the average person. She says she got this information. Now, we need to keep in mind that the state intelligence function sits in the presidency, and that can create some convoluted instances and some instances where there may even be conflicts of interest, where if the president were to feel that people are coming for him or he's the one who's being looked for in terms of prosecution, then he could give information to the director of prosecutions to look another way. And we've seen issues with this confluence of intelligence and prosecution as it pertains to presidents in the past. This is not the first time that we've looked at this. So her mentioning this intelligence report but not giving further information, I think, was something that needs more examination. We've seen intelligence reports being weaponized to get compliance, to create paranoia. Without more information about the agency information that she received, a cloud is created where we cannot pierce that veil and actually get to the bottom of what was said. Was it said to help her, or was it said to create paranoia? Was it said to create anxiety? Was it said to create a narrative which would then make her feel as if there's nothing to prosecute? All of these are things which need to be examined much further. Fourth point, I think that there's a conflict of interest in the issue of the implicated prosecutor being invested by the head of IDAC, who is Advocate Andrea Johnson. IDAC right now is being accused of not having any oversight, of being part of the interference and the complicity. We know that the husband of Advocate Andrea Johnson works at Crime Intelligence. We know that the affidavit filled in by Fidel Adams was taken to IDAC even when SAP's processes were not exhausted. We know that IDAC refused to provide that affidavit to the parliamentary committee and was giving excuses for why they could not provide it in a way that was not satisfactory. We know that it's the IDAC case that has led to the arrest and incapacitation of General Dumisani Khumalo, who was investigating the cartel, had just arrested Katiso Molefe, and who had also done search and seizure operations against Vusimatala Wetsamanyala. So we know all of that. And to be honest with you, the arrest of General Dumisani Khumalo seems to be an attempt to stop him, in my estimation, and from what I'm seeing. It does not seem to be a bona fide criminal case, and it does not seem to be something that arises outside of the purposes of slowing him down, slowing down his team, undercutting his team, and potentially removing him and replacing him with somebody who will not pursue these issues at Crime Intelligence. The evidence presented by General Dumisani Khumalo, Witness X, Witness A, Witness B, Witness C, was compelling. Videos, photos, cell phone tower data, text messages, audio messages. We heard it all, we saw it all. And as such, because of the volume of evidence presented, the strength of the evidence presented, I think that General Dumisani Khumalo was acting in a way such as to stop this Hosh Curry cartel and to bring it to its knees. Anything that seems to be stopping him, as things have been presented now, seems to be an obstruction of his course of duty and an obstruction of them working. Now, they get information from National Commissioner Fanima Semola and also from General Dumisani Khumalo that there's a prosecutor who's working somehow to interfere with the work that they're doing there. Now think about this. We've already seen how generals have been implicated in working with these cartel leaders. We've seen cars going to collect chocolate bags. We've seen video footage of police officers going to visit Katiso Molefe in jail to deliver tracksuits and trying to deliver food. We've seen that. With our own eyes, we've seen that. We've seen messages from Brown Mkhwanazi talking about the task team that was persecuting you has been dissolved. We've seen messages where police information seemed to be in the hands of criminals. We've now seen how the Hawks went in an inexplicable manner to the house of Katiso Molefe at the Molefe mansion. All of these things we've seen with our own eyes. So when there's an implication that IDAC is somehow involved in preventing the full process of General Dumisani Khumalo working, then we hear that the issue of this implicated prosecutor is being investigated by the same IDAC. I think there's a conflict of interest there. I don't know what you think. Before we go on, have you subscribed? We're aiming for 130,000 subscribers by the end of the month of November. So we've got about 20 days. Let's push. Let's end Hosh Curry behavior. Let's make sure that we grow the platform. Let the public know that such a great platform exists where we think through the current affairs issues, politics, crime, law, whatever the case may be, and look at them and try to get to the bottom of them. So if you haven't subscribed, subscribe, share the video, comment, do the things that need to be done. Now, my fifth point. Actually, I need to just say something towards the end of my fourth point. The decision to give IDAC the investigation of this implicated prosecutor, it's taken together with all of the other information and the confluences that it creates, it gives a reasonable apprehension of bias that there is actually interference in the investigation of this prosecutor who now will not be named to the public. That's something that I think needs to be said. Now, I want to move on to my fifth point. I'm still concerned that the NPA did not appeal. You know, bail was discussed today. The NPA did not appeal the Katiso Molefe bail decision. A man we've seen being implicated in tender fraud, a man we've seen has criminal records and firearms records, convictions in other jurisdictions in the UK, a man who is accused of participating in a heinous murder and facilitating payment for that murder, a man whose relatives absconded from the law. All of this has been proven in voice notes, has been proven with photography, with video. We saw the cars, we saw everything that Katiso Molefe is accused of. He's granted bail inexplicably because Katiso Molefe, Vusi Matlala, is not granted bail by the same court. The NPA did not appeal that decision. I'm concerned about that. The decision to grant him bail was confusing to me because of the nature of the allegations. The rationale of the decision was not persuasive. Equally, the case of the young lady earlier this year who was killed by men who were out on bail. And we've seen how some crimes are being committed by perpetrators who are out on bail, who are abusing the system. Bekele also spoke about this. I thought that after the Omotoso matter, they would have a greater appetite to restore their reputation and to show that they're willing to fight. Them not opposing the Katiso Molefe bail, to me, seems as if it's a strange decision. Number 6, there are some cases where the NPA, in my estimation, has not handled things well, and this has been reflected in the judgments of the courts and in some of the statements made by judges in those courts. And if you think about the Omotoso court, the NPA was criticized profusely by the public, by the judges. In the Gupta extradition matter, the UAE courts have thrown out that application. If you think about the Schultz case, which was another extradition matter, there was strong criticism of the NPA in that judgment. Then you think about the Cholota judgment, the Moradi Cholota lady who was working as the personal assistant for Ace Magashule. The Free State High Court judge, Philip Lobster's ruling, found that the extradition was unlawful and also was scathing of the NPA. There's also the decision not to charge anyone in the Phala matter, which was made by the Limpopo Director of Public Prosecutions. And then you've got the issue of, there's a case, a judge referred a matter to the DPP in Limpopo about a municipal manager in 2009 who approved a tender unlawfully. This company had not tendered, and this company then won, and the municipal manager is the only person who had the authority to approve the tender. The judge was so concerned about the matter, he referred the matter directly for criminal prosecution about this municipal manager to the public prosecutions. Nothing has been done so far about that former municipal manager. That former municipal manager is now a senior minister. You can find the story if you look for it. Now, we've also heard so much about the minister Thembisi Melane, who was implicated in the issues of the VBS Bank. No prosecution decision has been made. So if you think about the Phala decision where they were like, nope, nobody to charge, nothing to see here, move on. Then you go to DPP in Limpopo, who has not made a decision about the municipal manager, the 2009 issue of the unlawfully approved tender, where a judge referred the matter. Then you think about the Thembisi Melane matter. These seem to be political decisions made by the NPA not to prosecute particular powerful people or people within a particular faction. There's a man who is accused right now, of looting Tembisa Hospital. People have died as a result of that hospital not having resources. People have died as a result of trying to stop the looting in that hospital. And that person who was killed is Babita Deokaran, who was a whistleblower trying to stop that. Billions are alleged to have been stolen. This man is still a free man. We know IDEC can have referrals, but we also know IDEC can initiate their own investigation and arrest based on Section 28 of the NPA Act. We know that much right now. There's a man, Hangwani Morgan Maumela, free today. However, while none of these decisions have been made, there's another man, General Dumisani Khumalo, who has been arrested for what remains an HR matter. How is this HR matter more serious than VBS? How is the HR matter more serious than Tembisa Hospital corruption? How is this HR matter pertaining to General Dumisani Khumalo the matter where we've seen rapid action and prosecution, whereas there are a multiplicity of cases where people are still saying, where are the arrests? Where are the convictions? only after the IDAC matter was being discussed in Parliament did we see Malusi Gigaba then getting some action. But he wasn't even taken through the indignity that General Dumisani Khumalo was taken through. That's something peculiar. And the only reasonable explanation is that General Dumisani Khumalo and his team were getting close to some powerful people and he had to be stopped and slowed down at all costs. That's what it looks like. That's what it appears to be. And that decision is part of what contributed to General Mkhwanazi taking the drastic action of holding that 6th of July press conference where he mentioned name. But on the 5th of June, the National Director of Public Prosecutions, Shamila Bathohi, was making allegations that her own department is infiltrated but was unwilling to mention names. The difference is just glaring. It's glaring. I must say, I did not buy the refusal to mention names on the basis of protecting someone's reputation or their rights. An allegation is simply that. Names have been mentioned on full blast at the ad hoc committee and at the Madlanga Commission. The purpose of those vehicles is to determine the veracity of the allegations. Systems are not captured by ghosts, they're not captured by ancestors, they're captured by people for other people and in the interest and furtherance of particular aims. Now we don't have full clarity on certain elements and a key allegation. As the public, we may never know. And these things that can get classified, sealed, people are leaving their jobs, you may never get the full answer. And this is why I think I started with and I will end with the maxim of the judge in Rex versus Sussex. It says, justice must not only be done, but must also be seen to be done. Further, nothing is to be done, which creates even a suspicion that there has been an improper interference with the course of justice. Nothing is to be done, which creates even a suspicion that there has been an improper interference with the course of justice. Let's meet in the comment section. You tell me your thoughts. Soon and very soon, we are going to see the horse. Soon and very soon, we are going to see the horse.